I too would like to start by thanking our co-hosts for the invitation to speak today. I also commend each and every one of you. You're in the home stretch. We're at the end. You've made it through the day. And thank you for staying. I know there's very stiff competition. I know there's a golf show down at the other end of the hall, so thank you for staying here today. It's appreciated. I'm going to jump through the first few slides very quickly so we can get to the nuts and bolts of the chorus agreement. But there are some very substantial benefits that will kick in starting next week, and by some measures, almost 80% of duties are eliminated immediately on manufactured goods, and that number jumps to 95% within 5 years. The U.S. already has free trade agreements with 17 countries, so there's a long history of enforcement and compliance. Korea was at a competitive disadvantage prior to the chorus agreement with respect to these countries, and they'll be on an equal footing going forward. So that's the good news. If I'm an exporter sitting, or producer or exporter sitting in Korea, why should I care about enforcement? Generally speaking, it's going to be, as Greg indicated, the responsibility of the importer. Even if it's not an affiliate, there are ramifications if a preference claim is denied. And I think they're fairly obvious, but your customer will be billed for the duties. If it's a pattern of noncompliance, and it's particularly egregious, as Greg outlined, there may be penalties. More importantly, your shipments to other customers may be subject to greater scrutiny, to examination, not just the customer who failed to provide the supporting documentation, but your whole business may be affected. And under the agreement, you sitting here in Korea as an exporter or producer, if you provide a false certification of eligibility, you may be subject to penalties. The agreement explicitly contemplates penalties for false export certifications in amounts equal to penalties for import violations. Additionally, there are some fairly obvious commercial ramifications. The customer may cancel the order. They may cut off business entirely. They may even sue you for damages. I'm going to skip over these contract clauses so we can get to the nuts and bolts of the agreement. But as a practical matter, as a commercial matter, based on my 35 years of doing this, and you know this better than I, that buyers will use their leverage essentially to push all responsibility for compliance and all liability onto the seller. So you're going to see some very difficult contract language. Now, sooner or later, somebody will probably look at the documentation with respect to your goods. I know there's been an earlier presentation today with respect to the resources that Korea is putting into compliance. We know, and U.S. Customs anticipates a great deal of cooperation from the Korean authorities because they're interested in getting reciprocity from the U.S. side. To get cooperation, you have to give cooperation. Now, the U.S. already has very significant resources in place in terms of FTA enforcement. At the front lines, they have almost 1,000 import specialists at 300 different ports of entry around the U.S. These are the people that review the entry documents, the supporting commercial documentation, and they send out requests for information if they have questions. Additionally, there are 100 trade specialists at Customs with responsibility for analyzing trade data in different industries. There are also more than 500 auditors out there in a position to conduct financial audits of import companies. And when they make a request to the importer, typically they go back to their vendor, their seller, and ask for supporting documentation. Now, because of its long history in terms of enforcement under the old quota regime, I'm going to use textiles and apparel as a case study today to examine U.S. Customs enforcement strategies, the resources, and some of the tools they use. But these examples really can apply across the board, not just to textiles and apparel, but almost any product. Just as an aside, there's a reason that apparel has gotten attention over the years. Some of them I list. A very powerful domestic industry. Because of the high rates of duty on apparel, almost 50% of the duties that Customs collects are attributable to textiles and apparel. This is only going to continue and maybe even accelerate under KORUS. I think there's a pretty widespread perception in Washington that the Korean apparel industry is not vertically integrated. In order to comply with this KORUS agreement, they're going to have to source material inputs in the U.S. or apply for what we call short supply exemptions. We also know that Korea is in close proximity to China, and there are some cynics out there that suggest that they may give rise to circumvention of the agreement, the use of impermissible Chinese inputs or wholesale transshipment. Again, using textiles and apparel as an example, it provides some very good numbers and examples of the kinds of strategy, resources, and tools that Customs utilizes to enforce compliance under the free trade agreements. First and foremost, they try to identify high-risk, potentially high-risk shipments. And again, using textiles and apparel as an example, in New York there are 20 specialists at a commercial center, and there are another 9 policy analysts at headquarters dedicated just to reviewing import and export data in connection with textiles and apparel. And they will assign countries a relative risk designation. And as soon as KORUS is implemented next week, one would expect that shipments from Korea will automatically receive a higher relative risk designation in Customs' automated targeting system. What are some of the specific risk indicators? What are some of the red flags that Customs looks for? I mean, it's common sense. If they see a shipment from a new company, there's no history of shipment to the U.S., that shipment is more likely to get examined. Even where you have an established company that has a track record of shipping to the U.S., if they start to ship new and different products, or if the quantities shipped to the U.S. dramatically increase over a short period of time, they move to the top of the pile, the top of the list. There's also intelligence that Customs gathers from industry. Maybe competitors file a complaint, or a whistleblower says something about his or her employer. Customs will also review the intelligence they gather internally. And that intelligence essentially comes from 3 main sources. And these are the tools that Customs uses under free trade agreements. I'll stick with the textile and apparel example, but this has application across the board. First and foremost, I mentioned before that there were 950 or so import specialists around the U.S. 300 of them have responsibility for reviewing textile and apparel shipments. And they send out information requests, what I refer to as a desk audit. They want questions answered about a specific shipment. They want supporting documentation. And over the last several years, these information requests from the ports of entry have, I'd say there were about 5,000 targeted trade preference verifications issued annually. That's a pretty big number. Compare that to factory visits, which is the second major category of enforcement tool employed by Customs. And I know most people under KORUS are anxious about on-site verifications, and they should be taken seriously, but if you look at the numbers, they pale in comparison to these import specialist-initiated requests for information. Under the various free trade agreements that the U.S. has administered over the last several years, there are approximately 250 to 350 apparel or textile factories visited each year, compared to 5,000 targeted requests for information, paper requests. If they do come to your factory, what do? Well, they will ask to interview key management to determine how the company is run. They will ask for a tour of the factory, and they will analyze production capability. They'll look at the number of employees, their job descriptions, the number and types of different machinery. Maybe most importantly, they will ask for documentation, supporting records on 1 or 2 recent shipments. And you're given a fairly short turnaround time to provide that documentation. The third type of tool will be a post-importation financial audit. And again, I provide this so you get a sense of the relative numbers. Approximately 60 of these financial audits are commenced each year with respect to textile and apparel importers. So you look at the numbers, 5,000, 250 to 350, 60. So the most likely way that an examination will be initiated will be an inquiry from an import specialist. And great care should be taken in how they are responded to, and I'll get into some examples in a few minutes. Now, what are the historical results of these verifications? Well, they're pretty disappointing. They've averaged about a 40% failure rate when all 3 of these tools are combined. When you look only at factory visits, that failure rate jumps to more than 50%. And the most common problems resulting in a denial are fairly obvious, should be anticipated. That would be a failure to meet the applicable tariff shift rule, that the documents reveal a use of an impermissible third country input or inadequate production, or just a general failure to present adequate supporting documents. Maybe there are missing documents, maybe they haven't been translated adequately, maybe they haven't been presented in a timely fashion. Okay, so we know that the countries are serious about enforcement and compliance. They have devoted some resources. There is some political pressure out there to make sure that they're adhered to. What are some of the things, what are some of the practices that as an exporter or producer you should consider employing? Well, I think first and foremost, well, let me jump back for a second. Under CORUS, there are some specific and new enforcement tools that are available. Under Article 4.3, Paragraph 2A of the agreement, there's a new targeting tool. And again, I'm using textiles and apparel as an example, but it gives you a pretty good sense of how this is going to work. On an annual basis, Korea is obligated to provide U.S. Customs with a list of all apparel and textile factories that are shipping goods to customers in the United States. As far as I can recall, this appears only in one other U.S. free trade agreement, which is the Singapore Free Trade Agreement, so it's pretty new. And that list, that annual report, will contain very, very specific information. The names of the owner of the factory, production capacity details, again, number of employees, types of machines, number of machines, even the names of the factory's U.S. customers. There is another provision under Article 4.1, Paragraph 11 of CORUS, under which either Korea or the U.S. may publicize the names of people found to be issuing false certifications. So if you provide as an exporter or a producer a certification that turns out not to be supportable, that turns out to be false, the U.S. can publish your name. Now, I've spoken to people in Washington. They have no current intent to do that, but they're aware that they have that ability, and that could change. There is precedent in the U.S. for this kind of thing. Under the old quota regime, when a foreign company was found to be transshipping, especially Chinese goods, through another country, Customs periodically put their name on a list and put it on their website. We refer to that as the old 592A list, and as Greg indicated, that's the civil penalty statute in the U.S. If the company's name appeared on that list, they were done. Nobody would buy from them because they knew the goods wouldn't clear customs. So if that should happen under CORUS, it's pretty much a death sentence. All right, again, we know that the two countries are very serious about enforcement and compliance. So as an exporter or producer in Korea, what are some of the things I should consider? What should I do? I think, once again, most of these points are obvious, but they bear repeating. First and foremost, you need to know the rule of origin that applies to your product line. Clearly, it's not a problem if everything is done in Korea. If all the inputs originate in Korea, all the production takes place in Korea, we don't need to talk about that situation. But when that is not the case, then most products are subject to a tariff shift rule. We know how that works. We've that's been discussed, and that each and every non-originating material used in the production has to undergo the applicable change in tariff classification that's specified in the rules of origin. Annex 6A has the general rules, 4A the rules pertaining to textiles and apparel. These tariff shift rules presume a working knowledge of tariff classification principles. So, for example, you need to know things like unfinished versions of an article or parts of an article are often classified in the same tariff provision as the finished article. You can't have a tariff shift change. You also, as Greg pointed out, need to know the classification of both the finished product and all the non-originating inputs used to produce the finished product. I'll talk about a 2006 U.S. court case that illustrates both how these principles work, a typical dispute under a free trade agreement, and some of the procedures that come into play. Cummins Engine, a pretty large company in the United States, under NAFTA, sourced some steel forgings in Brazil. They sent these forgings from Brazil to Mexico to their related facility. In Mexico, they worked on these forgings, and they produced finished crankshafts. The intention was to take these crankshafts, send them to the U.S. duty-free under NAFTA, and use them to produce diesel engines. Prior to the first importation, they went to U.S. Customs and they applied for ruling. U.S. Customs looked at the facts and determined that these forgings, when they entered Mexico, were essentially unfinished crankshafts. They had been manufactured to the point where they were dedicated to use as crankshafts. There really was no other viable commercial use for them, so that both the forgings and the crankshafts were classified in the same tariff provision in Chapter 84, and there was no tariff shift change. In fact, there couldn't be. Cummins didn't like it and challenged the ruling in court, and the court looked at the facts and decided in favor of Customs. In fact, they issued a summary judgment. Just as a sidebar, and that's a typical FTA dispute, as a sidebar, before the case went to court, U.S. Customs went to the World Customs Organization, outlined the facts, and asked for a WCO classification opinion. And by, I recall, as a vote of either 32-1 or 33-1, the World Customs Organization issued a classification ruling supporting U.S. Customs' position. Now, that's not terribly surprising because private parties like Cummins don't have standing. They can't put their position before the WCO. It's only the customs administrations that can. So they used that WCO classification opinion in court to support their position. They did win the case, but significantly the court said that WCO classification opinions are not binding in the U.S., and most are entitled to respectful consideration, which is a good thing because, again, as a private party, you don't have a right to put your case before them. Now, there are other rules besides the tariff shift rules. Probably the major exception to the use of a tariff shift rule is in the automotive industry, and that, again, is because very often you're talking about parts, and you can't have a tariff shift rule, so they use a value-added approach instead. And there are three different kinds of methodologies, which I won't get into today because they're very complicated. But on the simplest level, they require either a minimum amount of originating materials or a maximum amount of non-originating materials. And if you exceed the ceiling or don't meet the floor, you have a non-originating product. And again, getting back to that whole notion of tariff classification principles, again, because parts are classifiable in the same provision, generally speaking, as the finished article, there are certain other exceptions to the tariff shift rule. Parts of footwear, machinery, appliances, TVs, computer screen parts, they use either the build-up or build-down method under chorus as opposed to a tariff shift rule. All right, you've done your homework. You know the specific tariff shift rule that applies to your product. What else should you do? What else do you need to know? Well, there are also very general rules under the free trade agreements, including chorus, that may impact the result. So you need to know the general rules that apply to your product as well as the specific rules. And again, I'll just quickly go through a number of general rules in the textile and apparel industry. There is a concept that I will refer to as essential character, and that's unique to textiles and apparel. And under this essential character concept, the tariff shift rule need only be satisfied with respect to the component that defines the garment, that provides it with its tariff classification or its essential character. So, for example, if you look at a shirt, you only need to satisfy the tariff shift requirement with respect to the material that forms the front and back of the shirt. You can ignore the material in the collars and cuffs. Moving along, there's a de minimis exception, which often saves a product under the rules of origin. And that allows for a certain small amount of non-originating materials. It's not essentially zero tolerance. So for textiles and apparel, that's a 7% leeway. But again, you're only looking at the component that determines the essential character. With respect to other products in general, that de minimis rule is 10%. But again, to show how these general rules interact with one another and the tariff shift rules in general, there are exceptions to the exception. You have to know the rules. So, for example, with respect to elastomeric yarns, spandex is the most prevalent example. That doesn't qualify under the de minimis rule. This is zero tolerance. So while you normally get 7%, if spandex is in the garment, you get 0. And that applies outside of textiles and apparel as well, most notably to dairy and agricultural products. So if you're shipping those to the U.S., you have a zero tolerance for non-originating materials. There's another rule that comes into play occasionally for textiles and apparel. It's the visible lining rule. So if you can imagine my suit, there's a visible lining in my suit. This visible lining rule operates as an exception to the essential character test. I said you normally would only look at the material that forms the body of the suit. Well, there's a special requirement that visible linings in suits and certain other garments be originating. So again, you have to see how the rules apply both generally and specifically to your product. There are a number of other general rules that come into play from time to time. Applying to sets. In the interest of time, I'll go through these very quickly. Packaging materials and indirect goods. So indirect goods are things that are used to produce the product but are not incorporated in the product, like lubricants, testing equipment, things of that nature. They're generally ignored. You don't have to meet the tariff shift rule with respect to packing materials, indirect goods. There are rules on fungible goods. In the interest of saving time, Greg did speak about the direct shipment rule, and I'll let you take a quick look at this. There are exceptions to that rule, so if you're merely unloading and loading the goods, I mean, there is a June 1995 ruling under the Israel Free Trade Agreement where some Israeli surface-mounted networks were shipped to an affiliate in Mexico. They opened the boxes, they consolidated the Israel material with Mexican material, they closed the boxes up and shipped the goods to the U.S. Simply opening and closing the boxes didn't disqualify the product. Again, if the goods enter the commerce of an intermediate country on the way to the U.S., it may cause a disqualification under direct shipment. How does that work? As a practical matter, it doesn't come up often, but when it does, it's usually triggered by something in the documentation. So if the bill of lading shows a third country as the final destination, as opposed to the U.S., that will trigger an inquiry. If the terms of sale on the commercial invoice for the product indicate FOB intermediate country as opposed to FOB Korea, somebody may ask the question. If the documents reflect a change in title, if the goods were sold in transit, they may ask. Just quickly, one last point on this direct shipment requirement. There's perhaps one less obvious scenario that comes up from time to time that people don't think about. And I'll refer to that as an outward processing arrangement. That's a situation where you begin the production in Korea. the good qualifies based on the production in Korea, you send it out of Korea to a third country for some intermediate minor processing, and you bring it back to Korea and you finish it. So-called outward processing. And there's a lot of that done from time to time. There's a 1999 NAFTA ruling that illustrates how that can get you into trouble. In that case, which involved shirts, there was cotton spun into yarn and knit into fabric in the U.S. The fabric was then sent to Costa Rica to be dyed, and later sent to Mexico to be cut and sewn into finished shirts. And what customs held was that the U.S. originating fabric, or the fabric produced in the U.S., lost its originating status when it was sent to Costa Rica for dyeing. Now let's jump ahead very quickly to documentation. A couple of general points on documents. As an importer, you can make a claim for FTA treatment under chorus, and that certification can either be in electronic or written form. It can be provided by the exporter or producer or the importer, assuming the importer has information to support the originating status of the goods. Throw all of that out. As a practical matter, most importers will insist that the exporter or the producer provide the certification because they're in the best position to have information about what happened and to be able to provide supporting documentation. Some other general points on documentation. The certificate, which supports the claim, can cover a single shipment, or it can be issued on a blanket basis for a 12-month period. It needn't be in any particular format. You can do it any way you want, but it has to provide each and every one of these data elements. Most importantly, the tariff classification of the goods and information demonstrating that the product is originating. Record keeping requirements under chorus. An exporter or producer that provides a certification must maintain the supporting records for 5 years. They can come back any time within 5 years and ask you to prove that the goods qualify. Filing deadlines under chorus. If you don't make the claim at the time of entry, perhaps because you didn't have the certification in your possession, you still have a year to make it from the date of importation. But under a number of court cases, it's clear that the U.S. and the courts will support customs position to construe these time limits very strictly. Ford, Xerox, a lot of large companies have challenged these time limits in court, and they've lost. Sufficiency of supporting documentation. What happens if customs comes and asks for information? Either the import specialist issues an inquiry, or it's a result of a factory visit where they ask for documentation on a specific entry, or as a result of an audit, your customer comes back to you and asks you for supporting documentation. Well, a couple of points. First and foremost, customs will closely examine the supporting documents. It's very clear that they'll parse the language very, very carefully. Here's an example, and I'm not sure if you can read the highlighted portion. There were 2 affidavits that were submitted in support of the claim, the free trade claim. In the first case, the affidavit was rejected because the signature, the affiant's signature, was supposedly illegible. The import specialist said they couldn't read it, so they threw the affidavit out. In the second affidavit, it was a CAFTA claim, and under CAFTA, the yarn that's used to sew the garment parts together has to be from the U.S. And talk about how closely the affidavit was read by the import specialist. The affidavit referenced both yarn and thread, and the import specialist threw it out, saying it should have referenced only thread. I mean, they look at every single word in these affidavits, and if there's anything that they have a concern about, they reject them. Now, normally you get 20 days to come back to them, but you should be very, very careful when the supporting documentation is put together. Another example. This is a situation where the affidavit stated that the input in question was, and here's the key words, will be sold. And the import specialist rejected the affidavit, said it was unacceptable because it should have said, instead of will be sold, that the manufactured item was purchased by or sold to. In other words, it happened, not that it might happen in the future. So they go back and they look at every single word, or some of them do. A second takeaway, another point, is that customs will look for an audit trail, a connection between supporting documents, and they'll also look at the manner in which the document ties into the specific shipment under examination. And there's an October 2011 fairly recent ruling from Customs that illustrates this point. There was a claim made under the U.S.-Israel Free Trade Agreement involving electrostatic, so-called ESD coats. And the import specialist at the port of entry initiated a post-entry inquiry asking for supporting documents. So naturally the importer went back to its vendor, its supplier. The exporter went back to the various companies that produced the garment. And as a result, invoices from the fabric manufacturer, the cutter, the sewer, airway bills, a detailed explanation of the manufacturing process, identifying each different company involved was submitted. Even cost of production information was submitted, and yet the claim was denied. And if you look at the ruling, it's interesting in that Customs looked at the documentation, and it came away with several concerns. The fabric manufacturer's invoice described the fabric as being in chief weight of cotton, but the coats were in fact made of man-made fiber. The fabric manufacturer's invoice indicated the quantity in meters, but the invoice from the dyer, the next guy in the chain of production, set forth the quantity in kilos. Customs headquarters concluded, they decided that they didn't dispute the fact that the garments were actually produced or were of Israeli origin, because the supporting document clearly evidenced that the exporter bought the fabric and had it processed, cut, and sewn into garments in Israel. But the denial was based on the fact that they couldn't tie the submitted documents into the entry at issue. So they had no problem with the fact that the garments were of Israeli origin, but the specific documents didn't tie into the shipment. They denied the claim. Now, a very important point. The agreement's not in effect yet, so this is probably a little premature. But based on my experience, it is incumbent upon both the exporters and importers to keep up with any changes. If you don't follow what's happening, if there are changes made, it's a big, it's potentially a big trap. As an example, under the CAFTA, the U.S. renegotiated a fairly minor and obscure origin rule. On a going forward basis, the pockets on pants, little pockets here, had to be made from originating material. In return, the U.S. granted very major concessions to our CAFTA trading partners. They liberalized the rules of origin on a whole bunch of garments, including women's suits and men's dress shirts. In return for this minor pocketing rule, which was negotiated at the behest of a very small specialty manufacturer in the U.S., whose congressman went to Customs and said, you know, we need this rule change to keep this guy in business. After the new rule went into effect, an importer submitted this declaration to Customs. And I don't know if you can see it, but all of the material inputs, with one exception, were from the U.S. There's a minor and passing reference that I highlighted to polyester lining of Chinese origin. So after this was submitted to Customs, the import specialist actually got on the telephone and called the importer and asked if the garments were lined, because there was a reference to lining. And the importer got on the phone and said, no, they weren't lined. The import specialist didn't give up. She asked for a sample. The sample was sent to Customs, and on review, the import specialist noticed that the pockets in the garment were made from two different materials. Half the pocket was made from U.S. origin fusible lining. As originating fabric, it was no problem. The other half of the pocket was made from that Chinese fabric and disqualified the entire garment. So what happened here? And by the way, it was a Korean company, for what it's worth. The importer didn't keep up with the changes. They were both unaware of this new pocketing rule. They didn't know it was on the books. And they were also confused about that visible lining rule that I mentioned earlier. They thought that only visible linings had to be originating. And because the pocket material wasn't visible, they thought they were okay. But they didn't know about the pocketing rule. As a result, Customs went back and increased duties for all their open entries for the course of a year, resulting in a $3 million duty liability. No penalties, just duty. The company went out of business. They filed for bankruptcy. What's really essentially tragic about this is that Chinese lining cost about a penny or two per garment. It added almost no value to the garment. Now, for those of you who are still awake, and I commend you if you are, and you were listening to me, you would say, Alan, well, why weren't they saved by that de minimis rule? I mean, it's only a penny or two a garment. If you recall, the de minimis rule only applies to the component of the garment that provides it with its essential character. That would be the fabric comprised, used to make the body of the pants, not the pocketing material. Even more tragic here is when the U.S. fabric was sent to Guatemala to be cut, there's enough leftover material to make these pockets at no additional cost. It would have cost them zero to comply. They just didn't know that the rules had changed. So you say to me, what relevance does this have to chorus? I'll give you an example. There's no pocketing rule under chorus, but if you recall, I told you that there was a de minimis rule and there was an exception for spandex. So you can imagine a situation where a Korean company makes a 98% cotton, 2% spandex t-shirt. The fabric is 98.2. They ship it to the U.S. Lo and behold, a 2% spandex is subject to zero tolerance. It's an exception to that de minimis rule, and the whole garment's disqualified. You put that same 98% cotton, 2% spandex in the elastic waistband of a pair of pants, and it doesn't disqualify the garment because it's not the component that determines the essential character. So you do have to understand the general rules as well and how they work together, as well as the specific rule that applies to your product, the tariff shift rule that applies to your product. Moving along very quickly, getting to the end, there is an unfortunate complication that was caused because of the long period of time between the end of negotiations and the implementation. It's been years since this chorus was negotiated, and it's only going to be implemented next week. The agreement refers to tariff provisions in two major places. One in the rules of origin, and the other is in the duty elimination or staging schedules. All of those tariff references in the agreement are to 2002 nomenclature, 2002 tariff provisions. We're in 2012, the last time I looked. The first inquiry I had under chorus, I went to look. I was told the goods were originating. Assume they were originating. Tell me whether the duties are phased out in 1 year, 5 years, 10 years. I looked. I didn't find a tariff provision because it had changed. There were a number of changes between 2002 and 2007, very few since 2007, but you could find yourself in a situation where you're looking at the current tariff schedules. You can't find that provision, either in the staging schedules or the rules of origin. Half the problem will be resolved. It hasn't happened yet, but the USTR has assured me that they will publish updated schedules, including the 2002 nomenclature before the 15th, before this agreement goes into effect, but only for staging or duty elimination purposes. The base rates in the agreement are 2006. Those will be updated to 2012 as well before the 15th. But with respect to the tariff shift rules of origin, it'll be months before those are changed to reflect 2012 nomenclature because both countries have to agree. It can't be done unilaterally by the U.S. It has to be done bilaterally. So that's going to continue to be an issue. If you're unlucky enough to have a product that experienced a change in nomenclature since 2002, you have to be a little more creative. You have to find a provision that most closely resembles it. I would recommend that you make some inquiries that you've done it correctly. Okay. What are some of the key takeaways? You know, just to kind of summarize where we are so far. I can think of at least 4. You have to know both the product-specific and general rules of origin that may apply to your product. You should also know that these rules will be applied strictly. If you make a clerical mistake or you have a good faith misinterpretation, doesn't matter. Customs hands are tied. They have to apply the rules as they're written. It is the classification opinion of the country of import that counts. We see disputes all the time under NAFTA where the U.S. and Canada disagree or the U.S. and Mexico disagree. It is the U.S., if you're shipping to the U.S., it's U.S. Customs opinion as to the classification of the inputs and the final product that matters. Now, there are all kinds of ways that, informal and formal ways that the two countries can try to work it out, but it doesn't help you commercially. I mean, that could take a very long time. It would be very expensive before that's settled. So it behooves you to know what the U.S. is thinking before you ship. And keep up with any changes. Now, I'm getting to the end, I promise. This is all very technical stuff, very complicated, somewhat dry. The benefits are clear, but the risks are very, very severe as well. But there's help out there. You shouldn't despair. There are things you can do. Greg spoke about some of them. I will speak about some others. If you go to Customs' website, there are almost 100 informed compliance publications. And they cover many different products and discuss at great length how these products are classified, how Customs goes about classifying these products. So if you go on their website, you'll see these informed compliance publications on things like ball bearings, beauty products, apparel, flat panel displays, machine tools, internal combustion engines. If you're lucky enough that your product has been the subject of one of these, get it, read it, understand it. There is even a informed compliance publication. You can see how thick these things are. How do I read the tariff shift rules? And this discusses the tariff shift rules for textiles and apparel under each of the U.S. free trade agreements. Side by side, they analyze the rules of origin under the Israeli Free Trade Agreement, NAFTA, CAFTA, AGOA. Hopefully within a few months, they'll update this to reflect the rules of origin under KORUS. So the Customs website's a good place to go. I've started to see under other websites, like the Agriculture Department in the last few days, issued some good information as to what U.S. exporters to Korea should know about KORUS. Presumably, on the Korean side, they'll have similar kinds of electronic or internet available advice. As Greg mentioned earlier, you can also apply for advanced rulings, and hopefully you'll have better luck than Cummins did. Just very quickly, the agreement calls for advanced rulings to be issued within 90 days. Customs can't take forever, but it's 90 days after the receipt of all required information. Those rulings are binding on Customs, and they can only be revoked retroactively if they're based on inaccurate or false information. You can apply either to New York, the Commodity Specialist Division in New York, or Customs Headquarters in Washington for a classification or tariff preference eligibility ruling, but only in connection with prospective, that is, future transactions. That's why they call them advance rulings. If your goods are on the water, it's too late to ask. Some tricks of the trade. Historically, New York has issued these rulings much more quickly than Washington. They usually come out within 30 days, with one caveat. Under the Customs ruling procedures, if your product is subject to one of those value-added tests that I talked about earlier, like a net cost determination for car products, for automotive products, you have to go to Washington. New York can only deal with tariff shift rules of origin. You should know, as Greg indicated earlier, that most, if not all, of these rulings are eventually published. So if you get a favorable ruling, you can't hide it from your competitors. Since the ruling is going to be published, you should also request confidential treatment for any proprietary information. You want the names of your customers. You want transfer pricing information, cost of production records redacted. You don't want that in a public ruling. If you don't like the ruling, either from New York or Washington, you can ask Customs Headquarters to reconsider it. There's an administrative appeals process. Similarly, if two ports are treating your product differently, if it's disparate treatment, you can go to headquarters and ask them to consider the matter and decide which port is handling it correctly. So I guess the fifth takeaway is if you're not sure under the rules, if you need help, don't be shy about asking for it. There are resources out there, and there are also a lot of people that have some expertise, so get the help. What can you do internally? What are some of the self-help measures? What are some of the best practices I would recommend? Greg mentioned appointing a central person in the company to assure compliance. You should appoint a compliance officer. I think that's excellent advice. Some companies where the sourcing is very complicated will actually draft a compliance manual, and that compliance officer is in charge of keeping that current. If there are changes in sourcing supplies, there are procedures in the manual to let the compliance officer know. It's not a bad idea to conduct internal periodic audits to make sure that over time nothing has changed, to take a qualifying product and turn it into a non-originating product. When you conduct those internal audits, you want to do a few things. You want to confirm that there's a linkage between the inventory and accounting records. There should be tie-ins. Anybody looking at those records should be able to go from A to B to C to D. Obviously, you also want to conduct that internal audit to confirm FTA eligibility. So I guess my key takeaway is that an ounce of prevention is worth a pound of cure, as our great American Ben Franklin said 250 years ago. If you address the problem after you ship the goods, it's much less likely to result in a favorable outcome than if you know about it up front. Last but not least, last slide. Under chorus, not everybody will be an immediate winner. You may have goods that for one reason or another are not eligible. You just can't source some of the materials, or some of the production has to take place outside of Korea, or you have an originating product, but you go to the staging schedules and you see that duty is not eliminated for 5 years or 10 years, or in the worst case 12 years. There are 11 different staging schedules and exceptions to those, so that in reality there are like 20 different phase-out schedules. So it may be 10 years before your product goes to zero duty. This is a very good time to go back to square one and analyze your sourcing structure. See if there are any opportunities out there that you may have missed. Maybe you can restructure transactions to get some favorable treatment even outside of course. This is a good time because the competitive environment is only going to get tougher. And I can give you a couple of examples of what I'm talking about. In some rare cases, but it does happen, there may be a partial duty exemption available to you under Chapter 98 of the tariff schedules. So for example, if you go to the U.S. and you buy fabricated U.S. components, send them back to Korea, and you take those U.S. fabricated components with other components and you assemble them into a finished product. When that product comes back to the U.S., you can deduct the value of those fabricated components from the overall dutiable value of the product. You don't pay duty on the cost or value of those U.S. fabricated components, even if the goods don't qualify under chorus. Another great example is what I call first sale, or the first sale rule. And if you structure transactions properly under this first sale rule, which is only available in 3 jurisdictions in the world, U.S., Europe, and for some reason New Zealand. Nobody else has this rule. If you structure the transactions properly, then you obtain a very favorable duty valuation. How does the first sale rule work? Well, for example, you may have a situation where the factory is not selling directly to a U.S. importer. They're selling first to a Korean trading company. The Korean trading company turns around and sells to a customer in the U.S. So there are actually 2 sales before the goods come to the U.S. Factory to middleman, middleman to the U.S. If you qualify under the first sale rule, you can pay duty on the factory price to the middleman, and you legally, lawfully avoid the duty on the middleman markup, which can be substantial in some cases. So again, go back, review all of the transactions. Kamsahamnida. Thank you all for listening today.